The general rule when it comes to GST and the sale of real property, whether residential or commercial, is that real property sales are always taxable unless it is specifically exempt under the Excise Tax Act. However, many lawyers overlook this. Our files reveal common mistakes on the part of lawyers, and they often involve knowing what transactions are exempt from GST and confirming who is actually responsible for collecting GST. I'll share with you our top 3 tips based on errors that we encounter in real estate transactions where the GST is payable. Let's begin with what transactions are exempt from GST. Although not an exhaustive list, exempt sales include 1. Used residential complexes, unless they have been substantially renovated. 2. Land or residences acquired for personal use, unless the land has been subdivided into 3 or more parcels. And 3. Residential land, such as residential land leases or trailer parks. Who collects GST? Generally, it is the owner or the vendor of the real property that is required to be registered for GST and to collect and report the tax. However, in some cases, it is the purchaser that may have the obligation to self-assess and report the GST. A common claim that we see is where the purchaser claims a right to self-assess the GST. However, the lawyer for the vendor fails to obtain the purchaser's GST registration number and ensure that the number is valid. The vendor is not only left on the hook for the uncollected tax, but will often have to deal with the added stress and inconvenience of potentially paying penalties and interest. Moreover, the seller may incur additional expenses in having to pursue the purchaser for the sales tax. Also keep in mind that the uncollected tax could be in the range of tens of thousands to hundreds of thousands of dollars. So here's our top 3 tips when it comes to real property transactions. 1. Remember that GST adds a layer of complexity to any sale of real property, so make sure you have a basic working knowledge of GST and ensure that you are up to date on the law. Also, when it comes to claiming a GST exemption for your client, make sure that you not only understand all the requirements, but ensure that you are obtaining and documenting your client's responses. It may take months or even years before your client learns that they have been denied an exemption, and a written record is valuable evidence when it comes to defending a potential negligence claim down the road. Number 2, take the time to properly and thoroughly review the contract. Don't forget that generally, if a contract for taxable property is silent, GST must be added to the purchase price. If the contract does not state who is responsible for collecting the GST, consider how to deal with the collection of GST early on in the retainer. Don't leave it to the day of closing. Many of our claims could have been avoided had that been done. On a related note, make sure to carefully review the statement of adjustments to ensure that GST has not been missed and that the calculation has been done correctly. Finally, if you are acting for the vendor and the purchaser is collecting the GST, ensure that you obtain their GST registration number early and confirm that it is valid. This can be done by either calling the CRA Business Inquiries line or by searching the CRA GST web registry. GST is a complicated area involving many legal issues, including statutory liabilities, exemptions, and rebates. So develop a working knowledge of GST and keep up to date on the law, because although you may fail to properly turn your mind to GST, chances are the government won't.